In 2013, Canada's own prison watchdog investigated racism against black inmates in federal penitentiaries. 10 years later, that same watchdog came back and said one thing: nothing has changed. Welcome back to The Wire. We cover human rights and criminal law inside the Canadian prison system. Today, we're breaking down the numbers and why a federal court just ruled that judges must account for it. Black people make up 4.3% of the Canadian population, but 9.2% of federal inmates. Between 2002 and 2012, the black federally incarcerated population grew by 80%. These numbers don't happen by accident. In 2013, the correctional investigator published a case study on the black inmate experience. What they found inside the walls was discrimination, racial stereotyping, and labeling. Not isolated incidents, but a pattern. Black inmates are 1.5 times more likely to be held in maximum security. They're overrepresented in segregation, solitary confinement, and in use of force incidents. This is what that pattern looks like in practice. They are also overrepresented in discretionary charges like disobeying an order or disrespecting staff. These are charges where the deciding factor isn't hard evidence, it's a staff member's personal judgment call. 10 years after that report, the investigator checked again. Their statement was blunt: discrimination and stereotyping remain relevant concerns, producing unequal outcomes. 10 years. Same problems, same conclusion. In 2021, R versus Anderson changed the law. Canadian courts now formally recognize impact of race and culture assessments. It is now an error of law for a judge to sentence a black offender without considering systemic racism. This is The Wire. We're not done watching.